The personal injuries guidelines quite clearly set out monetary values to be assigned to different types of injuries. However, a special difficulty arises in assessing damages under the guidelines in cases involving multiple injuries, which is often what we deal with in medical negligence cases. For example, there may be an alleged physical injury and an alleged psychiatric injury, and usually there will be a temporal overlap. While the guidelines value each injury separately, the difficulty is that if the courts award the stated damages for each individual injury, the claimant could be overcompensated, and the award could be unjust to the defendant and disproportionate when compared to other awards. Under the guidelines, the trial judge should identify and value the claimant's dominant injury, and then apply an uplift. This is to ensure the claimant is fairly and justly compensated for the additional pain, discomfort, and limitations arising from the lesser or non-dominant injuries. The guidelines do not specify how to calculate an appropriate uplift, and it has yet to be considered in a medical negligence case. A number of personal injuries cases have come before the courts and given some guidance, but it is clear that it is not yet a settled science.
In the cases we have considered, there have been multiple non-dominant injuries, and the courts have used different methods when calculating the uplift. In some cases, the judge has applied a cumulative uplift to compensate for the non-dominant injuries, without providing a breakdown of the level of damages allowed for each of the non-dominant injuries. For example, in Lipinski v. Whelan, a €25,000 uplift was applied to compensate for the non-dominant injuries. In other cases, the judges have given a detailed breakdown of the values assigned to each of the non-dominant injuries. The court then added the total of these non-dominant injuries and then applied a discount to the total of the non-dominant injuries. The discount was expressed as a percentage in McHugh v. Farrell and Collins v. Parham, but as a specified sum in Keogh v. Byrne. The overall discount applied to the total of the non-dominant injuries in most cases was between approximately 25% and 50%. The case of O'Sullivan v. Ryan provided a detailed analysis of the formula used in that case. Here, each non-dominant injury was assigned a value. Then the court applied differing percentage discounts to each non-dominant injury depending on the temporal overlap of the injuries.
Regardless of how the uplift is calculated, the overall proportionality of the award is the cornerstone of the guidelines. In Keogh and Byrne, the court recognised there may be cases where the combined effect of multiple injuries will actually be more severe than the sum of each individual injury. The court therefore also needs to take a step back from assessing the assigned values and look at the cumulative impact on the claimant, and consider awards for other injuries which would have the same overall impact on a claimant. The Court of Appeal in another case stressed the importance of looking to other types of injuries for a reality check. There, in reducing the general damages for a PTSD dominant injury from €90,000 to €60,000, the court considered the fact that severe neck injuries, which may require spinal fusion and involve significant permanent disability, are valued between €70,000 and €90,000, and that should act as a reality check. Further, the law expressly states that a court can depart from the personal injuries guidelines, as long as they provide reasons for this, though the courts have yet to avail of that provision. At least for now, while there are a number of different methods to calculate the final award to compensate a person who has sustained multiple injuries, the key is for it to be calibrated to ensure overall fairness and proportionality. We will certainly be awaiting any further developments.
There are other key takeaways, such as many sections of the guidelines give separate values for minor, moderate, or severe injuries, depending on the severity. A recent Court of Appeal judgment has highlighted how closely the courts will scrutinise what category a plaintiff's injuries fall into. In Collin v. CGR Construction, while the Court of Appeal agreed with the uplift applied for the non-dominant injuries by the High Court, it disagreed with the precise category the High Court had assigned for the dominant shoulder injury. The Court of Appeal reduced the award for the dominant injury from €75,000 to €40,000. Also, the guidelines do not cover all complex injuries such as damage to certain organs or vessels, which is frequently seen in medical negligence cases.